Hi there, I'm attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning for everyday families. And today I want to talk to you about how to keep your child's inheritance out of your in-laws' hands. So about 40 to 50% of all marriages in the U.S. end in divorce. So regardless of how you feel about your child's spouse, you really have to face the possibility that they could become your child's ex-spouse someday. And should that day come, the money you leave to your child could be subject to a division of marital assets. But with careful estate planning, your child's inheritance can be kept safely out of the hands of their spouse or former spouse. So let's talk about separating inheritance money from their marital assets. Now, during the marriage, the lines between what each partner owns, those can often get a little blurry. Generally, whatever is acquired during the marriage by either partner becomes marital property that is subject to division in the event of a divorce. But there are some exceptions. One exception is a bank account that is kept separate during the marriage. So inheritance money that you leave to your child or monetary gifts that you give to your child during your lifetime can theoretically go into a separate account. However, in practice, it can be difficult for spouses to avoid commingling those bank accounts. Even something as simple as depositing marital money into the account or using it to pay bills during the marriage could make that account marital property. Now, a better way to keep your child's gift or inheritance separate from their spouse's money is to hold it for them in a trust account. It is not just wealthy parents who leave money to their children in a trust. A trust is a flexible and powerful estate planning tool that allows parents of any means to exercise greater control over the money and the property that they pass down. So let's talk about trust management and third-party trustees. Holding your child's inheritance in trust involves doing a few things. You place your money and your property in a trust. You name a trust beneficiary, for example, your child. You name a trustee, someone who's going to manage those trust distributions for your child, and you leave written instructions that specify how the money and property are to be used. And those written instructions are just the trust. So while it's possible to name your child as both the beneficiary and the trustee of the trust, absent any additional restrictions, that kind of structure negates the point of establishing a trust for the purpose of preventing spousal commingling. Similar to how commingling can occur with a separate bank account, if your child uses money in the trust for marital expenses and then gets divorced, the court could consider the trust funds to be marital property. In order to avoid commingling, you can name a third-party trustee to manage the money on behalf of your child. And this takes the control of the trust out of your child's hands and places it in the hands of that third party, who can then use their discretion in interpreting the trust instructions for how those trust funds are to be used. Instead of distributing money from the trust directly to the beneficiary, which raises the possibility of commingling and trust division in a divorce proceeding, the trustee can pay third parties on the beneficiary's behalf. For example, if the beneficiary needs a new vehicle, the trustee can pay the car dealership. Or for larger purchases such as the home, the trustee could loan the money to the beneficiary. The house would be used as collateral to secure the debt to the trust and protect it from that asset division. Your child could be the trustee or a co-trustee. So giving a single third-party trustee sole discretion over trust fund distributions affords maximum protection against that asset commingling, but it provides your child with limited flexibility over how they can spend their inheritance. If you prefer to give them more options but still protect the funds that you leave them in the event of a divorce, you can name a third party to serve as co-trustee with your child. However, there's other restrictions that may be appropriate for creditor protection and tax purposes if those are needed as well. Now, when setting up a trust, there's several types of trustees that you can choose from, each with a different set of responsibilities and obligations. So for example, you might name your child as an investment trustee, giving him the authority to invest money held in a trust. In this capacity, your child is acting on behalf of the trust, not in a personal capacity. So the trust money is not commingled with marital assets. Now, at the same time, with good investments, they're effectively growing their own wealth. You can then have a co-trustee handle distributions for your child's benefit. Naming co-trustees has other benefits as well. In the event of a divorce or creditor issues, the child can resign as trustee, leaving the other trustee with sole discretion. You can also set up the trust in such a way that an independent co-trustee can make distributions to your child for any purpose, but your child is limited to distributions for health, education, maintenance, or support. So that's what we call HEMS, or HEMS provision, or an ascertainable standard. And while this does not provide the maximum creditor protection, because any distributions made to the child could be susceptible to creditors, the accounts remaining in the trust may still be protected. In addition, special consideration must be given to the beneficiary's ability to remove and replace another co-trustee. To create a bulletproof trust strategy to keep your child's inheritance out of their spouse's hands, you must take a wide view of everything that could happen. And that includes a possibility that you would probably prefer not to think about your child passing away. Now, should your child either predecease you or pass away before receiving the full benefit of the trust that you established for them, the trust may, by default, be inherited by their spouse unless you have planned for this event. And you can keep this from happening by naming a contingent or a backup beneficiary to your child. This could be your grandchildren, your child's sibling, a charity, or any other party that you specify as next in line as the trust beneficiary. In addition, be careful when giving what's called a testamentary power of appointment to your child. This power would allow your child to direct trust property or their share of trust property to another individual upon their death, and that person could be their spouse. As the creator of the trust, though, you can limit who the trust property can go to, such as your child's children or maybe just other descendants only. Now, keep in mind, you have the ability to take control of your legacy. All you need to do is talk to a trust or an estate planning attorney to make sure that you do that. And part of being a parent is protecting your children from their own lack of foresight. If your child is newly married or in a marriage that is headed in that wrong direction, you can take steps to keep your hard-earned money from falling into their spouse's hands, where it may not benefit your family, by creating a trust. Now, flexibility is one of the most powerful features of a trust. There are many types of trusts to choose from, and they can be customized with any number of provisions to ensure that your final wishes are fulfilled. Remember that an estate plan can and should be revisited. You can include restrictions in the trust now and remove them later as circumstances change. You can also decide to do away with that trust altogether if that's what you choose. Whatever plans you have for your money and property, you want to make the most of them by making sure you get the proper help from an estate planning attorney. So if you live in Massachusetts or New Hampshire, we're more than happy to help you with this type of planning. So please feel free to reach out to us and make sure you like and subscribe to our page as well. I want to thank you for watching. I'm attorney Kelly Longtin from Kelly Longtin Law.